what the judge says, in essence, I will convict. She says it completely, it's set out fully. With all due respect, you're taking a couple of words, but clear and concise is less than beyond a reasonable doubt. That's almost clear and convincing evidence, which is below a reasonable doubt. We should have been the ones objecting. If you really want to put it in those terms, she said she could follow the law. She would have no problems following the law.
I'm sorry.
Yes, sir.
Which case would, from either Florida Supreme Court or the U.S. Supreme Court, talks about extending these type of Batson challenges to religious groups?
There is a Florida case about Jewish people that I cited.
Joseph.
Yeah, Joseph. There is another case out of California that extends it through religion that I think was quoted in a Florida case, but it's quoted in my brief.
Right.
There is another case that goes in, and I can juxtapose from the second part of the argument, Heller, which was a jury deliberation case, but about Jewish people, and then the Minnesota Supreme Court case, which is directly on point.
But that one, they went the other way.
They went the other way, but the dissent would have extended it. We're talking, this was only 7 years after Batson. Now we're talking 17 years after Batson. So we've had an extension of Batson.
How about Florida Supreme Court? What's your argument for that requiring us to extend it to religious?
Well, I think you have. Let me give you an example of what I think. The Florida Supreme Court was the first court in the country to have a Neil Slappy. And just digressing, 1 month after that, I was trying the case in Oklahoma in federal court and did use that. And they told me I was crazy because it was Swain was the controlling. That went up. My case went up the same time as Batson. I argued it for retroactivity a couple months later. That was an extension of what the Florida Supreme Court did. The Florida Supreme Court has extended, and I quoted some cases in here, and I just don't remember them off the top of my head, where the Florida Supreme Court has extended to different aspects of different things. And we have to determine whether or not you're going to allow the exclusion, and I think it's the Florida Supreme Court, of an entire religion. And if you're excluding an entire religion, is what Judge Levinson does, that's creating a class that is covered by Neil Slappy, by everything, or by logical extension. When you get to the third district, talking about the exclusion of Jewish people and things like that.
If I understand your position correctly, if Ms. Beach had said something like, because of my religion, I cannot sit in judgment of Mr. Pacchiana and Mr. Bellotti, you would agree that that would be enough to strike her for cause?
Absolutely.
Okay, but because Judge Levinson and the prosecutor went off their history of trying cases over X number of years, that in their experience, that's generally what Jehovah's Witnesses says, and although she hasn't said it, we believe that to be the case with her, that's not good enough for cause.
I don't think so. It's not good enough for anything. When he declined to voir dire her during the voir dire part of it, and then when the judge brings her in, and she gives answers that are 100% right down the way it should be, to be a fair and impartial juror, and has in fact sat on a jury before, I think it elevates itself to a I don't want to say prejudicial, a not good faith challenge.
What about the fact that at one point she was asked about sentencing, and she said, well, if I had to sit on the sentence, then I'd have a problem. And then someone said back to her, well, you're not going to sit on the sentence. But the mere fact that she would say that, let's say she's back in the jury room thinking, well, if I find this person guilty, I'm playing a role ultimately in sentencing. Again, that's somewhat speculative, but there's maybe a reasonable inference to believe that may come into play and to determine whether she's going to find guilt or not.
It's been a long time since I read this record. Only because I had it on a computer. I live in a Tavernier, and I don't have internet right now. But I recall that there was discussions about the death penalty and whether she would be able to sit on a death penalty, and that's how that came up. And a Jehovah's Witness can't sit on a death penalty, obviously, because they would not be able to pass something on that. She said she could make a sentence, and I think the prosecutor or the judge brought up the fact that she would not be giving a sentence in this case. And the sentencing would not be something she would have to be considering.
Can I ask you about the case from the Florida Supreme Court, Happ v. State, where the state attorney responded by explaining, I'm quoting, that the juror, as a psychology teacher at a community college and a Catholic, was more liberal than people in other professions would be inclined not to believe in the death penalty. The Supreme Court concluded, we conclude the trial court was within its discretionary authority to accept the reasons given by the state as race neutral. How do you distinguish that case?
The death penalty case, number one, and they would not accept the death penalty. That is a huge difference. If you have a liberal college professor, an African-American, who would not accept the death penalty, that's an entire different.
Difference is the fact that there was that affirmative statement, and if that would have been the case here, you would.
If that juror had said that, as opposed to the prosecutor saying it, the prosecutor and the judge here undertook to ask this juror whether or not she could do these things, and she said yes. That's what distinguished Hap. I don't know if I did it in the reply brief because I know the state relied on Hap, but it distinguishes it completely because we have a set of factual circumstances here that evidence what the intent of the judge was and what the intent of the prosecutor were. It's almost as if, Rossman's a friend of mine, but he's like he was lying in wait, knowing that he saw this juror was a Jehovah's Witness. He never asked her a question, and when we brought it up, she came in and she gave every single answer that entitled her to sit on the juror. That is where the cases come in that I cited about excluding an entire class of people. And that's exactly what you're doing here, that can sit on a case, particularly when this person said she could. I'll go point two. I have no question. The second one was, of course, the issue of Eddie Arce, who was the crucial witness in this case, the main witness who, after he broke up with Kristen Bellotti 3 or 4 years after the commission of this offense, became a witness for the state. He was deposed, as I said out in the statement of fact, we had a lengthy Arthur hearings. He was deposed. He's an admitted perjurer, among other things. And 3 weeks before trial, at the start of jury selection, which I think was 5 weeks, I asked updated deposition. The judge said no. Conceitedly, it's within the discretion of the court to not allow the updating of a deposition.
But wasn't the point only that he had been convicted of or pled to petty theft and possession of controlled substance? He
had pled to a crime he didn't commit, and the petty theft hadn't been done yet. But that goes to my point of whether or not whether it's admissible or not admissible necessarily, whether or not we should have delayed the testimony to let us at least investigate.
Well, did you have in your mind something that you thought you would glean from the deposition, or just because of the age of the prior?
Well, initially, before I asked to delay the testimony, I just asked for a deposition just to update because I don't know what he'd been doing. He gave 4 different statements. He admitted he lied. He did this different things. I wanted to take an updated deposition, limited from the time, as we do in civil cases sometimes, from the time of the last deposition. I asked it to be limited to that. Judge Levinson said, no, you're not taking a deposition. And as we know, then we find out there's discovery violations the day that Mr. Archie's going to testify on a Tuesday. We learned a week before, or a Wednesday before, the prosecutor learns that the man has been prosecuted and has a pending case in Texas. And also on Friday before, learns that has some issues in New Mexico with some kind of fraud. And he doesn't tell us any of this at all during the pendency of that week, where we could have used the weekend to investigate. We have 126 years between the 3 of us that were trying this case of doing this stuff. We could have sent an investigator. We could have found out some stuff. He tells us nothing until the morning of trial. We had a lengthy issue where I just asked that the court delay his testimony. I asked for a private depo. He wouldn't let us do that. We're shooting blind. And I don't care how long we've been practicing, we're still shooting blind. There was no harm, and I cited cases where they found harm in not doing it, and allowing us to delay his testimony. This was going to be another 6 weeks of trial, 8 weeks of trial. I forget how long the trial lasted. For us to delay his testimony 10 days, 2 weeks, to let us at least investigate to determine whether or not what the prosecutor is telling us, based upon what an admitted perjurer is telling him, is something that we can go on. We don't know what we would have found in
It's unheard of when a denial is made of something like that you go ahead and tell your investigator, go ahead and do the investigation anyway, find out what you can, and that way we'll make another request of the judge, if not post-trial, to say, here's the mistake you made in denying our request. Was that ever part of this record?
No, it was not. I had already completed cross-examination before he decided to let us do anything to start with. And then he had to bring the person back on redirect. He redirected him, and it ended right then and there. because I did the cross that I was allowed to do, and then we went on to the rest of the case. No, nobody's come back on a motion for a new trial, and I think it was a reversible error, I submit, just to do it then. It was not, all of this would have been obviated if the judge had done the simple thing.
I suppose the slippery slope of that, because in many trials that you've tried and that we've tried, we have witnesses who are not the most savory of characters between the time they were deposed, if they were ever deposed, and they show up at trial to testify, and sometimes you're just going on what you have. So to say that this judge in this specific case, what was the exceptional reason in this case that says that this judge should have granted your request as opposed to all the other cases where these kind of things happen?
I think the cases that I cited in here, 2 from this court, show, and the first district cases, that at least the delay was prejudicial. I'm not saying he had to grant me the depo. I agree with you 100% there. He does not have to. I think it's in his discretion. I think he should have in a capital case. I mean, it wasn't capital. They waived the death penalty at the last minute. In a first-degree murder case to do that, but I think to not extend the testimony a little bit. I cited a case right out of first district, almost on point. And in this case, the case from this court, where the court suggested that it would delay the testimony to allow a witness to prepare himself, and he said, let me just talk to him now and I'm ready. And the language of this court about what should be done to ensure fairness, there was no harm to the state or anyone in not delaying this testimony a week. We don't know what we would have found, but we know he committed 2 more crimes. We don't know what the extent of the turpitude is when there was a direct TV involved in the thing in Roswell, New Mexico. Those are things we should have investigated. What we have to examine respectfully is this isn't a 1-week trial or a 2-week trial like most are, as you're talking about, Judge. This was a trial that went on for months. To delay this witness's testimony 2 weeks was absolutely required, I suggest. And further, it was required because of the negligence of the prosecutor and not notifying. It's a discovery violation. I mean, it's better than a Richardson hearing, I suppose, because he let us depose the guy, but the prosecutor still committed discovery violations under the new one that we're all required to take, that 3.1113, whatever it is, about updating all the Brady and everything. And that's supposed to be done immediately. He didn't do it. And the continuing duty to disclose, and a prosecutor with Mr. Rossman's experience of 27 years, knowing that he has the key witness who has 2 criminal matters, and not advising us till he starts the testimony, compelled the trial judge to grant at least a delay in the testimony. And I cited the cases, and I think those cases are binding. And the prejudice is still, we don't know. But we don't know what the cross-examination could have been, would have been, or would have shown. And certainly it would have been deflated to bring them back 2 weeks later and had that, oh, look at what they found now. That would not have served the purpose of a cross-examination. As you know, cross-examination is something that's fluid, flowing, and structured, at least for purposes of impeachment. And even when I got to do it on redirect, it had after the redirect, it didn't have the same effect as cross-examining him about all his perjurious statements and the things he did and the things that happened, and then bring that up. To bring it up a day later just takes all the sting out of it, and that's part of a good trial strategy, is to structure your cross-examination. It was a denial for these defendants on that. And I think the judge was wrong. I think the cases that I cite control and should be reversed on those grounds. No questions? Okay. The next one, I guess, is the admission of the testimony of Michael Kadosh. And Mr. Kadosh, as I point out, was a businessman rebuilding a hotel in Miami who became partners, whether willingly or not, with Mr. Bellotti, depending on what he said. And I think the court knows that Mr. Kadosh somehow met with the authorities some years after this case was over and made the statements that I was talking to Mr. Bellotti over lunch and said I had an issue with my daughter. My daughter, with her son and son-in-law, and Mr. Bellotti supposedly said he can be whacked for $10,000. Somebody was messing around with my daughter. I had him whacked, and now I'm paying out monies for attorneys and so forth. Of course, there's two fellows, that's Mr. Pacchiana and Mr. Bellotti have arguments on it. Mr. Bellotti, excuse me, argued that it shouldn't come in at all because the prejudice outweighed the probative value of any of it. Of course, part of it was an admission. The other part that we objected to was the admission of the testimony that he offered to commit another murder, allegedly. And we suggested there that that was other crimes evidence that was outweighed by any probative value. The prosecutor stated, and the judge found, that it was necessary to complete the story or inextricably intertwined, which I would submit is not so. They could have said, did you ever have a conversation with Mr. Bellotti where you talked about his daughter being, about your daughter being upset? The statement could have come out. There was no necessity for bringing out the offer to commit another murder other than to show propensity or to commit a crime or other evil intent, bad, ill will, whatever you want to call it. It was not necessary to show motive. It was not necessary to show anything.
So you're saying that part of it could have come in as admission, but not the whole thing?
Well, I've looked for every single case to get around saying it's admission. So I'm not going to be disingenuous with the court. It could come in. That part of it could come in. But certainly, I still think it was too prejudicial to come in, but that's the only argument I can make. I think the second phase of it was absolutely too prejudicial.
And you made both those arguments at the trial?
Yes. Yeah, I made the argument that, it shouldn't come in at all, but if it should come in, it should be limited to not the other murder. And
I'm sorry, go ahead and finish your answer.
that's all I'm going to say.
I'm trying to get in the minds of a reasonable juror. So Mr. Kadosh is supposed to come in and testify under your theory and say, yes, I know Mr. Bellotti. Well, tell me what Mr. Bellotti said to you one day. He said, well, I had my daughter boyfriend whacked. If I'm a reasonable juror, well, how the heck does that come up in a conversation? What's the context in which that came up? And that's the reason that it's intertwined, why the judge found in this case that it's intertwined.
Well, but we have to take that with what the cross and what the argument was. Nobody ever corroborated that statement. The police never did with him anything with it. He stayed out on bond for 7 more years. Nothing was ever done with that statement to show any indicia of reliability. I can't imagine a prosecutor on a first-degree murder case who opposed bond for these people, hearing that the defendant offered to commit another murder, not making a motion to revoke bond or doing anything about it. It belies what they did about the statement. They only gave us the name of Kadosh 2 months, 3 months before trial. It wasn't like they gave it to us 3 years before when they knew about it. Nobody was planning on using them. So to answer that question, part of it's true, but how would it come up? It could have come up in the way I said. They're having lunch. He's saying, I'm having trouble with my son-in-law. My daughter's all upset. And he goes, oh, I had problems with my daughter. Nothing had to be made about the murder. I suppose he has to eat about he's paying attorney's fees to keep him from singing. Nothing had to come up about that murder to put that in context. That was totally a prejudicial statement put in for no reason. Although I understand what the statement
I was going to say, they had a reason for
well,
putting it
obviously
in.
they had a reason to put it in, but I'm saying when it wasn't necessary for the admission. The bad acts evidence that establishes the propensity to commit crime, the willingness to commit a crime, detracted from the entirety of the trial, even for Mr. Bellotti, especially for Mr. Bellotti on that. And then we go to the second part of it, is whether it was admissible against Mr. Pacchiana. Mr. Pacchiana, attorney, moved to sever numerous times in writing and orally over this statement. And it doubles the argument for Mr. Pacchiana because the prejudice to him was overwhelming. When Mr. Bellotti says, according to Mr. Kadosh, that I had an issue with my daughter and I had him whacked, that connotes a murder, a premeditated murder in some aspect because he had it done, he had him whacked, and it certainly implicates Mr. Pacchiana, beyond a doubt, because Mr. Pacchiana has a defense of self-defense. So the impact to Mr. Pacchiana is incredible. And then, when they admit and allow the admission that if you're having a trouble with your
How
son...
many times was the request made to sever?
Judge, I can't remember. I know it was done in writing, it was done orally, it was done by objection when they were offering the evidence.
It was denied, obviously, each
It was denied every time. I mean, it was brought, we had a whole volume. There's a whole volume of testimony on this issue of the admission. Whether it's this court's case in Brown, which was ultimately relied on, getting rid of Machado and all the rest of the cases that are there. It was 250 pages, 200 pages of argument there. There was arguments on the severance before trial, every aspect
Can
of
you
it.
distinguish Brown in this case?
Can I distinguish Brown under the opinion that this court wrote as to what's the statement? I've been thinking about it for days. No, Brown, if you delineate what Brown interprets Crawford as saying a statement is, this probably would not qualify as into a Brown court statement. Statement has to be something that under Crawford is going to be considered testimonial. You would expect to be testimonial, anticipate testimonial. I mean, I don't want to be disingenuous with the court. That's what the Brown interpretation is. So you have to take it back. That's why Bruton wouldn't apply, because Bruton was, of course, a confession for the postal inspectors, and I think it applies. I think it has to go on partially on prejudice. I don't know. I mean, when you look at Brown, and then you go back to the cases cited there in Machado and all those, where would a reasonable person think that this might become testimonial, that Mr. Bellotti is saying something to another individual to be used? Considering the circumstances of what Mr. Kadosh says they met, probably. I would say so, yeah. Just you'd have to do it on a basis of the surrounding circumstances of the statement. But certainly to Mr. Pacchiana, more prejudicial again, even than the statement, and that's as prejudicial as can be, that he should have granted a severance, is compounded by the offer to do murder. I'm starting to sound like the Godfather. Like the offer for the other murder that was talked about, because to Mr. Bellotti, that puts Mr. Pacchiana almost in the situation of being Mr. Bellotti's hired hitman from what conversations. And that really inured to the detriment of Mr. Pacchiani and the entire defense that he had. So I think the admission of that statement as to Mr. Pacchiana in any way should not have come in, and it should have been a severance. I don't think there's any way around that a severance should not have been granted on that. And at the very least, it's that both of these individuals, the offer to commit the other murder, should never have been admitted. The next matter, better look at what I wrote, I think I would like to talk about lesser included in this case that we requested. We requested lesser included of conspiracy to commit aggravated battery and third-degree murder. The defendants were charged with conspiracy to commit first-degree murder and first-degree murder.
Did you get the lessers? You did get those lessers as to the murder charge, correct?
Yes.
But not on the conspiracy.
Yeah, as I recall, we wanted a conspiracy to commit aggravated battery. There was some testimony that R.C. might have gotten beaten up.
But let me ask you this. If the jury had come back with a lesser on the murder charge, then the failure to give the instruction on the conspiracy charge makes more sense. But because they came back with a guilty on murder, how are you now hurt by this?
If they had found, and Judge Levinson said he saw a basis for conspiracy to commit aggravated battery based on it and wouldn't give it. If they had found these defendants decided they were going to lure this kid and beat him up, and that is a conspiracy to commit aggravated battery, necessarily that is not one of the enumerated crimes under felony murder. Therefore, it would have been mandatorily a verdict of third-degree murder. They logically fit because a lesser of first-degree murder can be third-degree murder if it's a felony murder. They allege premeditated murder, but no matter what, if they committed a conspiracy to commit aggravated battery, and as I said again, there is evidence to support the conspiracy to commit aggravated battery. The judge so found.
Does the evidence support that lesser because Mr. Bellotti shows up to the house with a gun? He allegedly tells Mr. Pacchiana and the others, bring your pieces. they do. So how does the evidence even support the lesser of aggravated battery?
Well, because it was testified to. It was also testified that as things died down, everybody was joking around and they were leaving until Kristen came down with the 3 doors down, 3 doors down, whatever they are, CD, and things got riled up again. But RC thought, no, everyone testified, even Palazola and Corbin, the two co-defendants testified they never thought anybody was going to be murdered. They never heard of a conspiracy to murder. They denied a conspiracy to murder. That was in my sufficiency argument. They admitted that they thought there might be someone getting beat up, and then you get Archie and Kristen in the car doing what was going on. But certainly there was a thought. Mr. Bellotti is no different perhaps than a lot of fathers hearing that saying he's dead. He's got a gun. The thing about making the phone call and bring your piece is refuted by the evidence. That never happened. Eddie Archie's the only one who said that call was made. He said that call was made from Louise Bellotti's house, and Detective Yeager's timetable shows that call was actually made from Mike Bellotti's home in another area, and that they left to come up to Mike Bellotti at the time. It's just like the stuff with Chicago and the other stuff. Some of it's made up, some of it's not. That's for a jury, I understand. But certainly we've had evidence to support a conspiracy to commit an aggravated battery, and when you look at what happened when Mr. Archie showed up at Louise Bellotti's home, Mr. Pacchiana and he got into a fight. And they were fist fighting, and the words were said about how tough he was after it was over. Mr. Rojas had injuries to his body, looking like he was in a fight. Mr. Pacchiana couldn't take it. He was getting beat up, and Mr. Pacchiana was losing the fight. We have the word that Miss Bellotti heard, everybody heard, including the state's witnesses, that Richard said, "You're Big John, you hit like a," whatever the word was that he used, certainly belittling him. That indicates entirely that there was going to be somebody getting beat up. He didn't walk out with a gun. He didn't do anything with a gun to walk out. We have evidence that supports an aggravated battery. And Mr. Pacchiana was losing the fight, according to the state's witnesses, and shot him after he was losing because the kid was breaking into a home he told he couldn't come to. No one talks about the circumstances of Archie, coming. He's going to go into the house. Mr. Rojas, come into the house. He wants to get in, and he's not being allowed in. So we have the evidence that it may have been an aggravated battery. That being the case, then it was error not to charge on it. Don't forget, as the court well knows, any scintilla of evidence to support a jury instruction is all that required. And we had that evidence to support the giving of a jury instruction on conspiracy to commit aggravated battery, which mandatorily would have required a verdict of third-degree murder because of the delineation of what constitutes third-degree murder, commission of any other crime. And that would have been an aggravated battery. So I think that was reversible error. It was asked for. It was preserved 10 times in the record.
My question still remains, though. The jury didn't find your client guilty of any of the lessers under the murder charge. So if they didn't find him guilty of the lesser and the murder charge, how could this have harmed you? Because you think they're going to find him guilty of conspiracy to commit aggravated battery, but guilty of murder?
Of course not. They would know exactly what it is because the instructions would have been given, just like I still objected to the principal instruction being given. As you know, they only caught it at the last minute, and I couldn't stand on my own error that you couldn't give a principal instruction in a conspiracy case, but we don't know what that principal instruction did, giving that over in the case. So we don't know what the jury would have done. We didn't want lessers to start with. We objected to them. The state wanted some lessers. I forget how many they gave. I think just murder 2 or something like that. But still, in all, the jury would have necessarily found. We don't know if the jury wanted to find conspiracy to commit aggravated battery, or whether they would have. That's why you get jury instructions. Certainly, you would be correct if they would have rejected anything and they had that lesser instruction. Then, of course, we'd be foreclosed from the argument. But that does not presuppose that they might not have convicted on conspiracy.
So you didn't want lessers on the murder charge?
I can't remember.
On the conspiracy? That doesn't make it.
No, maybe we did of third degree. Yeah, I asked for a lesser of third degree murder. What am I talking about? I'm sorry. Yeah, I asked for the lesser of conspiracy and a lesser of third degree murder. I specifically asked for those. I think may have rejected the others because it would negate what the instructions were that we wanted, but we specifically asked for those. We had arguments about those. The judge made comments that he found a basis for the conspiracy to commit the aggravated battery. That being the case, he should have granted the instructions. The rest, I guess,
7 minutes. I want to see how much you want to save for your rebuttal.
I probably should save 6 minutes. Let me see what happens. I've talked for 34 already, so I'll rely on the brief on the rest.
Thank you, Mr. Haddad.
May it please the court, Melanie Dale Serber on behalf of the state. With respect to the first issue, the state maintains that the issue presented below was solely about the race-neutral reason. There was some discussion the day after the judge granted the peremptory challenge and found that the fact that that Ms. Beach was a Jehovah's Witness and what she had said after they brought her back out was granted peremptory. Again, it's a peremptory challenge. So the next day, a motion was filed, and there was some discussion about a religious-based strike, but there was never a ruling on this strike or this issue. And again, even after it was Counsel Bogenschutz made the claim regarding the religious-based strike, he then went on to again clarify to the court, so you're saying this is a race-neutral reason. So the issue is whether or not this was a proper race-neutral reason. The state relies...
Are you saying that we'd be foreclosed from reviewing it just because they use the words, I'm not saying they did or didn't, I'm just saying, but if they had hypothetically only said race-based, you're saying that you can use a religious or an ethnic or a gender-based, but if you don't say the proper words, it's not preserved. Is that
Yes.
your argument?
For this particular case especially, because no court in Florida has found that a religious-based strike is a protected class. That hasn't been found. That's not really what was argued in the briefs, but I haven't found a case in Florida that says that.
Joseph, you don't think comes close?
If you read the cases that are cited, and I can give you the list, I mean, I have Happ, Simonette, McKinnon, Hernandez, and Rodriguez all allowed religion as a proper race-neutral reason to peremptorily strike a juror.
Obrissis versus State, 929 Southern 2nd, 1176 from this court, where the court said, we conclude that whether the juror was challenged because he is of Pakistani origin or because his religious belief is Muslim, it would be a Neil Slappy violation to exercise a preemptory challenge of him on either account.
And I recognize the case law, but that is because that was a strike based on religion, and the objection was that you're striking this juror just based on religion. Now, here, they asked for a race-neutral
before
reason.
you go on, are you saying that you can or cannot strike somebody purely on religion?
It depends on the circumstances, I would have to suggest. It really does.
Obviously, I think Judge Gerber pointed out correctly before, if it was somebody saying in their testimony, I could not judge somebody, I think we would agree that would be a valid preemptory. But if someone said they can follow the law, can you then say, I don't want that person, judge, he's Jewish, judge, she or she is of Catholic or any other faith? You're saying that's totally acceptable in this
for a
court?
race-neutral reason, which is what was asked for in this case. I recognize there's a body of case law that is...
Had they said for religious, I mean,
if that had been the objection, yes, there could have been a possible issue. But again, I'm not sure that really applies in this scenario. We have...
On Obrissis, they also put, actually, the defense counsel used the term race-neutral in seeking the state's justification of a strike. Objections to preemptory of prospective jurors based on race, sex, or ethnicity may actually involve more than one of these classifications. The term race-neutral is therefore under-inclusive by 2/3 and hence unsuitable. A better term would be non-invidious. That's the one we've used here. So the fourth has already said, well, okay, you said race-neutral, but you meant ethnic and religious.
I would say in this case, that's not what was meant, because defense counsel came back and asked for a race-neutral reason. There was never any discussion on the record, are there any other Jehovah's Witnesses sitting? Are there any other religious jurors sitting? There was no discussion regarding that issue, which is the discussion that has to happen.
Is there any doubt in this record that this trial court or the prosecutor were clearly saying that the fact that this person is Jehovah's Witness in and of itself. I mean, we don't have to delve into circumstantial evidence to see what the reason is. Is there any doubt that that was, didn't the court say it'd be malpractice to allow that person of that faith to be on a jury?
A lot of things were said on the record regarding the Jehovah's Witness strike. However,
As the state thinks that that's appropriate?
in this particular case, under this scenario, it wasn't just one discussion regarding whether or not the witness was going to be struck. There was a peremptory strike. Again, a peremptory strike. The state brought the juror was brought back in.
You keep on saying preemptory. My question, then let me ask you, is it constitutional to do a preemptory strike, according to the state, on religion alone?
In
If
this
it's not
scenario,
based
yes.
On this scenario?
In this
Even-
scenario, because the
Why?
defense asked for a race-neutral reason, continuously asked for a race-neutral reason. The defense objected, wanted a race-neutral reason. The prosecutor then said she put on her form, she was a Jehovah's Witness. They brought Ms. Beach back in, and she gave the testimony, as Judge Gerber pointed out, regarding where she would hold the standards. And again, I would point out specifically, it was not about the death penalty. It was about the sentencing in general. She did say if she had to decide the sentence, it would be a different issue. She kind of wavered on what the standards were. She didn't.
She's not, was she supposed to be considering sentencing as a juror?
No, but the state went through the questioning, here I'm going to present the evidence. Well, if you provide me all of the evidence, if you provide me clear and concise evidence, then it would be fine. And that is where the crux of the issue comes. The prosecutor was delving into, you're a Jehovah's Witness, are your beliefs going to affect your ability to judge this case? But again, we were coming in for a race-neutral reason. After the juror was questioned again, I think the judge is finding that fair enough, and I will point out.
Prosecutor said no, but she put at the bottom that she's a Jehovah's Witness. That gives me pause. Defense counsel, that's a religious-based strike. Prosecutor, you can say that, but that's for 20 years. Defense counsel knows any one of them that's been practicing, they've always said that. Now maybe she's less, and then it goes on. That's page 2328, I believe, of the record. So, I mean, you can argue whether or not, I'm just trying to get to your theory of this. Whether it's preserved or not, we can discuss, but you're saying that, are you saying that had they said, I object as a religious-based strike, that it's still appropriate to use the person's religion as a matter of just course? I mean, with no evidence that it affects their judgment. Is that the state's position?
No, because that's not what happened here.
No,
There
I'm not
was
asking
evidence.
about what, I just wanted to get, to enlighten me, the state's position. Do you believe, is the state's position that there's a cognizable class, religion could be a cognizable class?
In reviewing the case law, I would say that that is debatable because there is case law that is differing on this issue. And again, I don't want to pigeonhole the state in every case that we're never going to be able to make an argument that this wasn't a proper strike. So again, for this case, we've got to focus on the facts as they came out here. And I wanted to point out to Your Honor
How
on
about State versus Allen? I mean, doesn't it say that the applicability of Neal to other groups will be addressed as cases arise?
Yes, and that's not this case. That's the position, and that's not this case. This is not a case where the state solely said, your religion, you're off the panel. It was, let's bring the juror back in and question her. And I would point out on 2328, the next statement by my opposing counsel wasn't that she was a Jehovah's Witness. They weren't even sure. So we brought the prospective juror back in, and they questioned her. And Ms. Beach, she says, the judge says, you indicated in your questionnaire you're a witness, Jehovah's Witness. Yes. How would that affect your ability to be fair? We've had them before. So it's clear that this court doesn't have a blanket policy of striking Jehovah's Witnesses. I understand what the arguments have been made, but that's not fully reflected in this record. You need to look at this record.
But if there was a blanket policy, the state would find that to violate the Constitution, correct?
Well, I think a judge always has to exercise discretion with respect to these, so a judge can't have a blanket policy with respect to jury selection, and I think that's long been the law.
So is it your position when Mr. Bogenschutz said at the very beginning of this on page 2327, that's a religious-based strike, that was not sufficient to preserve this as a secondary Neal Slappy challenge?
No, because later on, within the same page frame, after Ms. Beach comes in and counsel This prosecutor talks about my reasons unchanged. I don't believe I can meet her burden. There was some confusion as to whether or not it was a cause challenge. It was a peremptory. And Mr. Bogenschutz says, we're asking the court on page 23, 28, 32. We're asking the court to follow the law and tell us what the race-neutral reason is that's already affected your decision. So reaffirming that the objection for this juror was we need a race-neutral reason. And to reverse in this case, when it's clear from the record that a race-neutral reason was provided, and I think I've cited a body of case law that this reason is proper as a race-neutral reason. And as I listed, it's Rodriguez, which is 826 Southern 2nd 494, which is out of this court.
Is it your argument that you can have a mixed motive, one appropriate, one inappropriate, and therefore we're able to affirm on the appropriate, like when the trial court says she wavered a bit, I think he says at some point. Is that your argument, that there's a
No,
mixed
counsel
motive?
never secured a ruling on whether or not this was a religious
saying
based
it's not
strike.
preserved.
It's not preserved. That issue is not properly
Assuming
before
it's
the court.
preserved for the purpose of our discussion, then the question is there a mixed motive? Can you have a good reason and a bad reason, and therefore we affirm based on the good reason?
You know, I think in this case, based on her statements, that she would not possibly follow the law. I mean, in that sense, I mean, there's some wavering on, the prosecutor didn't just say she's a Jehovah's
What
Witness.
specific wavering? I'm a little confused.
It's her testimony, excuse me. And I think the prosecutor relied on this. If the state gives me all the evidence that I can see where you can show me that these individuals did this act, and that's on page 2330, the state has to prove it beyond a reasonable doubt. Not that they did it, proving it beyond a reasonable doubt. That is not the standard that she should hold the state to, and the state reiterated that.
This was, okay, but, you know, as was discussed before, she's a layperson, and, you know, so are we expecting jurors to, at the beginning of trial, recite the law as they're going to hear at the end of the trial? I mean, this seems to be a...
No. Again, the state then, after Ms. Beach gave her testimony, said, my reason is unchanged. I don't believe I can meet her burden. I can meet my burden beyond a reasonable doubt. This wasn't all about her religion. Her religion triggered the questioning. So this wasn't all about the religion from the state, and I think that's important to recognize. And again, the state is not wavering. That issue was not preserved, and nobody secured a ruling from the trial court.
Two things about that statement from the prosecutor. He does not refer back to anything she specifically said. Second, we know that this prosecutor moved to strike her before she said any of this, simply because she was a Jehovah's Witness.
As a race-neutral reason, because that's what was asked for. And that was a proper reason under the case law I've cited. Now, the parties brought her back in and they questioned her further, and the prosecutor's statement was, I mean, 50 lines after she testified. I mean, it was a short statement. That was really all they asked the juror. But again, we didn't have to rehabilitate the juror. This wasn't a cause challenge. This is a peremptory challenge. The state is establishing that, you know, I initially didn't want the juror on. I used the Jehovah Witness religion as the race-neutral reason. That's what this triggered.
Keep on about race-neutral, but let me give you a hypothetical. Let's say the state had said, Judge, she's a woman. I don't want a woman on the juror. And that's my race-neutral reason. Now, obviously, that's against the Florida Supreme Court case. Then, or there's a U.S. Supreme Court case on it, I think JB. Or let's say they had said, hypothetically, because you're Hispanic, my race-neutral reason. Well, that's against Allen. So my question is it really the fact that they don't say it's a race-neutral, but rather isn't the substance of what the objection, or are we going to just, because they put it under the title race-neutral, well, sorry, we can't do anything, because if you had said religion, maybe we could, but you said race-neutral. I just don't understand that argument.
Well, it's a preservation argument. I mean, I think, frankly, those scenarios were
If you
all...
hadn't said that argument as that we've recited twice, on that other page about the religious strike, that's a religious-based strike, your argument may be a little stronger, but it's hard to see, and especially didn't the judge say later that your objections are preserved?
I recognize that, but that doesn't necessarily preserve the objection regarding the religious-based strike. And frankly, providing hypotheticals based on different reasons, again, they're all fact-specific to each case. And in this case, if you look at the record, what happened was another motion was filed the next day, and the judge said, you were asking me for race-neutral reasons. I gave you a race-neutral reason, etc. That is the issue that is presently before this trial judge, and that is what the judge ruled on. There was no ruling that this was not a religious-based strike, or it was. And therefore, it's the state's position. This court can't delve into that in this case. There may very well be a scenario where it comes up. However, this case, the reason given was race neutral, and that's the state's position. And I recognize the difficulty regarding the issues because this was a long trial, a long case, a lot of motions were filed. However, you have to specifically find it, and it's 2327 to 2333 in the PDF on point 1. And again, the state would argue that the defendant isn't entitled to a jury of his choosing. It's a fair jury, and there is no indication in this case that the jury was unfair.
Yeah, but isn't it also true that we don't allow religious tests in this country too? It's in the Florida Constitution, and you can't say that to serve as a juror, you can't be of one religion or not be of one particular religion either. So it's not just a jury issue.
That may be the case for the juror. However, in this case, the defendant is entitled to a fair jury. And this was a peremptory challenge, so if the peremptory was improperly granted, it can be found to be harmless, unlike a cause challenge, and that's the distinction I was making, Your Honor. With respect to point 2, regarding redeposing Mr. Arce, the state would just point out that Mr. Arce was in fact questioned outside the presence of the jury. The judge ultimately admitted evidence regarding the collateral crimes, and just saying we don't know what we would have found doesn't establish a prejudice prong to show any prejudice, even if it was error not to allow the judge to redepose. If there are no questions, I'll move on to point 3. This is Mr. Kadash, and this affects both defendants in 2 separate ways. With respect to Mr. Bellotti, the state's position is when this issue came up pre-trial, there was a lot of discussion regarding the entire statement. What happened with this witness was he was a business associate. This is reflected in the transcript, and I apologize I didn't write the PDF pages at the top. However, there was evidence that they were business associates. They were at dinner, and they had a dinner, and these comments from Mr. Bellotti were made in a hotel lobby. So, that's the context of it, and because I don't think there's really an issue regarding the trustworthiness of the statements. It's really about the prejudice. All evidence is prejudicial. This was a statement against interest. The trial judge found that the statement regarding offering to whack the son-in-law for 10 grand because I've done it before puts the statement in context for the jury and explains how it came out in conversation.
Well, Mr. Haddad made the point today that the same admission could have been elicited simply by saying, well, Mr. Kadash is allowed to testify, I'm having some real problems with my daughter and my son-in-law. I don't know what to do about it. And simply could have left in the portion where Mr. Bellotti allegedly says, well, here's what I did when I had problems. Now, again, it's not the exact, that implies he's suggesting to Mr. Kadash that Mr. Kadash have it done by somebody as opposed by Mr. Bellotti for $10,000. It's still pretty prejudicial, but not as prejudicial as Mr. Bellotti saying, I'm willing to have it, I'm willing to do it.
Well, the state's position on that is that's relevant to show modus operandi, and this is how Mr. Bellotti does business. This is how things happen. So it puts it in context, but it also goes to show motive, intent, and modus operandi. Now, with respect to Mr. Pacchiana on point 3, that's a different scenario. Again, I put in context for trustworthiness because that argument was briefly touched on. The claim was that it was inapplicable and he was untrustworthy. However, there's nothing to establish that there was anything untrustworthy about the statement. What happened was happened in 2011, the meeting, and it was about a year after they'd been charged via indictment. So the meeting happened in 2011. And with respect to Mr. Pacchiana, this evidence is relevant because the statement regarding Mr. Bellatti's statement against interest, coupled with the evidence of the conspiracy, is relevant against Mr. Pacchiana. And if there are no further questions on that issue, I will move on. I believe Mr. Haddad is right to...
Jury instructions.
Yes, the jury instructions. Thank you. With respect to the jury instructions, I mean, I think that issue is a little bit confusing in the sense that with respect to the completed crimes, there were lesser includeds given. The jury found the defendants guilty of the first-degree murder. The conspiracy, the arguments that were made, I'm not sure that you can intend to commit a general intent crime with the conspiracy, and particularly with the aggravated battery. So I think that makes it even more confusing that they're not proper instructions to give to the jury because they wouldn't make any sense. And secondly, it would seem to me the harmless error argument in not getting them is the jury found the defendants guilty of the primary crime, so they're not entitled to then find them guilty of some lesser included created offense of conspiracy, because that's really how it came out in the record. It was very convoluted to read how the parties were asking for this. But
Although it does make sense, I understand your point, but it makes some sense that if the conspiracy was to beat the victim up, and they didn't really ever agree to the murder, then a conspiracy to commit aggravated battery makes sense. In other words, if they were all upset about what this guy had allegedly done, so if the theory was going to be that when they got him to the house, he was just going to get the beating of his life, but there was really no intent to murder, then conspiracy to commit aggravated battery makes some sense. Now, I tend to agree with you that ultimately they found them guilty of murder, so I don't know how this is harmful, but
it would also seem that a conspiracy instruction regarding a crime that doesn't require any intent doesn't make sense to a jury. You're intending to commit a crime that you have no intent to commit, because we don't have to prove, and there's no specific intent for an aggravated battery or the third-degree murder. I mean, we've gone through all of this when it comes to manslaughter with respect to the intent for the completed crime. And I don't know then how you could have an intent to commit a no intent crime. And I think that in and of itself.
My problem with attempted manslaughter, I've never understood that.
But, even if there was some error in failing to give this lesser, I think the state could make a very good harmless error argument. The defendants were convicted of the completed crime, and the evidence supports those convictions. So there's no harm in failing to give these lessers, even if there was some error. But I just can't see how they would ever have been a proper instruction such that a jury could understand it. And with respect to harmless error, I would rely on the arguments as raised in the briefs as I set out the facts in fair detail. And if there are no questions on any other issues, we'd rest and ask that you affirm convictions and sentences. Thank you.
Thank you.
Before I turn to the jury argument for a moment, if I may, Judge May, in response to Ms. Dale, the specific intent crime is a conspiracy. We deal with this all the time federally. You have to have a specific intent to commit a conspiracy. You can conspire to commit a non-crime, and that'll still make it a criminal conspiracy. Here, if they criminally conspire to commit an aggravated battery, that is a specific intent crime warranting the instruction, and then it would be a third-degree murder. Judge Levinson himself found that made sense. He got lost, as it were, and not understanding the third-degree murder aspect of it. But there was evidence to support it. It's a proper instruction. It is a specific intent crime. And I think that carries it. One of the things that I would point out is that in times when jurors are challenged by the defense, and the juror says, I think I can be fair, the courts have said they have to say beyond a reasonable doubt that they can be fair. And that if it's less than that, the judge has an obligation to exclude them as a juror. Mr. Rossman asked Miss Beach if she received all the evidence, because what she said is, if the state gives me all the evidence that I can see where you show me these individuals did this act, I can make a decision based on that, based that decision on what you provide me. And Rossman says, 2 lines down, you can do that beyond a reasonable doubt, and she said yes. I think that establishes her bona fides to be a juror, and there's no way around that. Further, before Miss Beach was brought in, the moment that
Wait, let me stop you there for a second.
Yeah.
Because it kind of seems like what you're arguing is that when you have a for cause challenge, and then you can establish that the juror can be fair and impartial, that then the cause is not there. But is that the same situation when you have a peremptory?
No, I'm not. I'm just amplifying the fact because of what the prosecutor said with the hesitancy of the woman, that she said she could be fair beyond a reasonable doubt. The prosecutor asked the question. He's bound by what he asks. He's the one making the challenge, that's all. And we, as soon as Mr. Rossman moved to strike her, when he said, I'll strike juror number 8, and Mr. Williams said race neutral, and Rossman said she's a Jehovah's Witness, and Bogenschutz says that's a religious-based strike, that puts the court on notice both ways. And what's not forgotten here, I would say, at least by me, is that next day we had a lengthy hearing because written motions were filed, the Minnesota case was cited, all of the arguments were had, and we filed a writ of prohibition in this court. This was way before the juror was sworn. This would be when it could still be cured. She could have been brought back. Anything could have been done. We asked for all kinds of relief. I mean, we had a writ was up here for days, and this judge was on notice. Everyone was on notice. This was a religious base, and when a judge says that it's malpractice to keep a specific religion, for the state to keep a specific religion, the intent of the state and the intent of the judge is clear. I hate wasting 3 minutes, but I thank you for your time.
Thank you, Mr. Haddad.
Thank you.
Court is in recess until 10 a.m. tomorrow.